everybody. Sorry about the delay there. Thank you so much for coming and to see this this distinguished panel. This is actually really interesting. Brings together a lot of different communities at the law school. So it's Data Privacy Day, which is actually at the end of the week. And we decided to do ours a little early, but basically Data Privacy Day is an international day where lots and lots of events all over the country, all over the world are dedicated to raising awareness of issues of privacy. And you can find out more about Data Privacy Day by going to dataprivacyday2010.org. And you can find lots of different events, of which this is probably just one of the first, because we're a little early. It also represents co-sponsorship between the center where I work, Center for Internet Society, but also the ACS and also SLATA. So many of you probably come from the Constitutional Society, come from the Law and Technology Society. So thanks very much for co-sponsoring this event and for all of the interest. So not to take up a lot of time, obviously the goal of today is to explain a little better about electronic communication privacy and to talk about where changes need to be made, if at all, and some of the efforts that are underway. We really couldn't have two better people to talk about this issue, in my opinion. Really absolutely at the forefront of the ongoing discussion about the Electronic Communications Privacy Act and the need for reform. So Professor Susan Freewald is with University of San Francisco School of Law. She is, many of you will appreciate the fact that she started off in software development, I believe, and so she understands the technology. Jonathan's nodding his head. But also is a very widely respected scholar of the application of the Fourth Amendment and of U.S. statutory law to the electronic space. She had written a number of influential articles, has been cited, I believe, by appellate courts, has been quoted by many, widely quoted, including recently by the New York Times, and has been helping in these efforts by working with the Electronic Frontier Foundation and with the ACLU of Northern California on specifically this issue, this set of issues. In addition, we have Kevin Bankston, who a name many of you will recognize as being a senior staff attorney at the Electronic Frontier Foundation, and he too has been right at the forefront of this issue, litigating some of the most prominent cases in the space and helping to coordinate the effort of digital due process, which is the leading and in many ways only coalition of reform that is getting a lot of traction, I think, on ECPA. He comes to the Electronic Frontier Foundation by way of a Brennan First Amendment Fellowship with the ACLU in New York, and again is widely cited, widely quoted about this and other related issues. Also has a article in the works, I hope, for privacy law scholars on a related issue as well, which I personally look forward very much to reading. I think it's going to be a really great addition to the space. Anyway, I took a lot longer than I wanted to. I just want to say thank you so much for coming. We all appreciate you being here.
Thanks, Ron.
Yeah.
Hi. So again, I'm Kevin. This is Susan, friend and colleague who I often work with on these issues, and so I'm going to lay out where we're going to go today. First, I'm going to talk about a very pertinent example in this space. Then Susan's going to take us on a magical mystery tour through the history of statutory and constitutional law in this area, with me accompanying on the whiteboard. And then we'll discreetly address two big topics in this area. First, Fourth Amendment and statutory protections for content you store online, and Fourth Amendment and statutory protections for location information, such as that collected by your phone company about your cell phone. So as Ryan mentioned, I work at the Electronic Frontier Foundation, a nonprofit based in San Francisco, where we seek to preserve digital civil liberties. Some people in this room, or at least one, have served as interns at our office, and I invite you, if you're interested in digital civil liberties issues, to consider doing that some summer. We pride ourselves on, like Tron, fighting for the user and making sure that you have the same rights online that you enjoy in the offline world, which will bring us to our first example. Warrants, and when are they needed? Does the government need a warrant to open your mail? Yes or no?
Yes.
Yes. Does the government need a probable cause warrant to wiretap your telephone calls? Yes. Do they need a warrant, barring an exception, to bust into your house and take your files from your file cabinet or to seize your computer? Does the government need a warrant to seize the entire contents of your Gmail account? Or not? Some confusion here, which is appropriate because there's confusion in the courts as well. And that's an issue that we have been working very hard on at the Electronic Frontier Foundation to establish that, yes, the government should have to get a probable cause search warrant to obtain the contents of your communications that you store with a third-party online service provider. But that's not quite yet the state of the law. Certainly not in terms of statutory protection. When we're talking about statutory protections for your communications data and content, we're typically talking about something called the Electronic Communications Privacy Act. And when we're talking about stored communications as opposed to wiretapping or monitoring who you're calling or who you're emailing with, we're typically talking about a particular portion of that act, the Stored Communications Act. That was passed in 1986, eons ago in internet time. And so we have some strange features in this law which we at EFF don't really think accord with reality as it is lived today by people who use the internet. A few interesting features of this law, which we'll get into a bit more later. It does require a warrant if the government wants to secretly seize communications of yours from a communication service provider, such as an email provider like Gmail or Yahoo or Hotmail or whomever. However, it only requires a warrant if the communication is less than 180 days old. After that, it can be obtained secretly with only a subpoena issued directly by a prosecutor without any oversight at all. I see some confused faces when I say this, because it seems rather arbitrary and not to make much sense. And I would say you're right, it's rather arbitrary and it doesn't seem to make much sense. Could anyone want to hazard a guess as to why Congress in 1986 would impose this kind of time limit? Hearing no one, I'll say that the reason Congress did this was because it reflected technology 25 years ago, which was you would dial into your bulletin board system / email provider and pull your email down and download it to your own computer, and it would be deleted from your email provider's servers. And so if you had left your email on that server for over 6 months, it was safe to assume, if they even would keep it that long, because storage was much more expensive back then, that you'd essentially abandoned that email and had no more privacy interest left in it. But that doesn't really accord with reality as we live it today. How many people here have years' worth of email stored with an email provider? Pretty much every one of you, except for those of you who know this law and, and try to protect yourself. So, you know, to my mind, my most important and private and sensitive emails are the ones that I keep for a long time, not the ones that I immediately delete. Yet that's not the way the law works. The law gets even wackier when you consider how the DOJ reads it. The law only protects...
Sorry, Department of Justice.
Department of Justice of the United States of America. The law only requires a warrant for communications that are in electronic storage for less than 180 days. Electronic storage, a defined term in the statute. I won't bore you with the details. It's a bit confusing. But the Department of Justice's argument, one that we strenuously disagree with and that the Ninth Circuit has rejected, but not yet any other circuit, is that a communication that you've opened and looked at is no longer in electronic storage, nor is a draft email stored with your provider, nor is an email that you've sent. Essentially, they're saying, to the extent you have looked at the email, the provider is no longer providing a communication service. They are providing a storage service, and therefore you're entitled to less protection. So basically, boiled down to its essence, the government's position is a warrant is required only for those few emails in your inbox that you haven't opened yet today. We don't think that's actually a sufficiently protective electronic privacy statute. And so we are working to change that, both in terms of combating that, to our mind, zany DOJ argument, and also to establish clear Fourth Amendment rules so that it's clear that the Constitution requires a warrant for your email. And finally, working to get Congress to update this statute, which is now so woefully out of date it simply doesn't make sense. So that's just an opening example. But to go a little deeper, we wanted to talk briefly about the history in this area, the history of government wiretapping and government access to communications data, and how the Constitution and acts of Congress have worked together, or sometimes at cross purposes, over the years. And for that, I'll defer to Susan.
Thank you. I'm going to sit. Let me just see a show of hands, though. How many people studied criminal procedure? How many people remember criminal procedure? Okay, so a lot of people haven't studied these cases, so I'm going to be a little basic to start. What we're talking about here is the standards by which law enforcement can get access to, we're talking about communications, so communications privacy, the standard by which law enforcement agents can get access to your communications as part of their investigation of you. And the question is, when do they have to present evidence that you've engaged in some criminal activity or they think you're a bad guy to a court before they can rifle through your stuff or wiretap you and the like. And the Fourth Amendment is based on the notion that the power to invade our communications or search us or what have you is very intrusive. And everyone's looking at him. What are you writing up there?
I'm just...
Okay, first of all, I did this handout. Does everybody have the handout? Many people have the handout. So I guess Kevin feels that it's sort of a belts and suspenders thing to do that as well as the handout. Okay, but look at me because it will make me know that you're understanding what I'm saying. So don't look at him. Okay. So under the Fourth Amendment, when the government is going to search through something in which you have a privacy interest, we want to make sure that the government has a reason to think that you've engaged in some criminal behavior. Okay? And we don't want the government just looking through people's stuff, listening to their calls, and the like, just because they want to. Because that is too big an intrusion on our autonomy. And so the Fourth Amendment requires the government have a reason, and we call it the probable cause requirement, reason to believe that they're going to find evidence of criminality in their search, and that narrows down the people whose privacy they can invade. The additional protection the Fourth Amendment requires is that government agents who are members of the executive branch have to show the probable cause to a neutral, what's called a neutral magistrate, which means someone in the judiciary, a judge, a trial judge or a magistrate judge. And they have to get that judge to approve that actually there is this reason to believe that they're going to find criminal evidence. And so that's the probable cause warrant. And so so when the Fourth Amendment requires this warrant before the search, you have the protection of the judge in between the investigator and your private information, making sure that the investigator has a reason to go through your stuff rather than just, I wonder what Freewald's been talking about lately. I'll listen in. Maybe I'll find something. Okay, so these cases, the history of these cases are the history of figuring out when the Fourth Amendment requires the warrant and when it doesn't. So starting off with the Olmstead case in 1928, the investigators planted a wiretap on Olmstead's home, and the question was, did they have to get a warrant before they did that or not? And the court interpreting the Fourth Amendment, the Supreme Court said, you know what, they didn't have to get a warrant. There was no Fourth Amendment interest. This wasn't a constitutionally regulated search. And the reason was, there was two reasons. One, that the agents never actually went into Olmstead's house. They were able to wiretap his calls. He was a bootlegger. And they were able to wiretap his calls from somewhere outside his home, from the basement of an office. And the second reason was that their court was very literal about what the Fourth Amendment protected. Persons, I can never remember it. Persons, places, things.
We're the experts here, folks.
Anyway, it's like persons, houses, effects. But they said intangible things like phone calls aren't covered. And so they said no Fourth Amendment protection. Now, this is an important point to recognize. Whenever the court withholds Fourth Amendment protection from a type of investigation, then the regulation of that investigation falls only to Congress. Congress can impose whatever restrictions they want or none. And Congress passed a law that regulated wiretapping for a while, but it was very ineffective. and it was broken all the time by both state and federal officials. So wiretapping was rampant all the way up through the 30s and 40s and 50s. And then in 1967, the Supreme Court addressed the question again, although technically in the Katz case it was a bug on a telephone booth. We don't have these anymore. We used to have telephone booths. I think we had it in that movie with Colin Farrell still, but no more after that. So there was a bug on the phone booth, and the court said, you know, we no longer require for there to be a Fourth Amendment interest that you actually invade someone's property. We've gotten rid of that requirement. And we no longer require that the thing searched be tangible. And so they got over the two hurdles that had held them up in Olmsted. So, but what's private and what's not? Something can't be private if you tell the world about it. But something can be private if you tell some people about it. For example, talking on the phone was something that the phone company was able to tap into. So the rule can't be that if anyone could possibly get access to this information, it's not private. And so the Supreme Court said, what are we going to do? And they came up with a rule to try to figure out when the Fourth Amendment applies and when it doesn't. And the rule is called the reasonable expectation of privacy test. And that's the rule in Katz, and that's the rule we still use today. And that's written on the handsheet. It requires a handout that a person exhibit an actual expectation of privacy and the expectation be one that society is prepared to recognize as reasonable. So if it turns out that the police are intruding on a reasonable expectation of privacy, Fourth Amendment applies, warrant requirement applies. If not, it's up to Congress to regulate the investigative practice, and they can impose whatever minimal restrictions or requirements they want. And when we get back to the ECPA statute, we'll see that for a lot of things, Congress has required next to no procedural safeguards. Okay, then comes Berger in 1967, and the interesting thing about Berger is that the court said not only does the Fourth Amendment require a warrant for wiretapping and eavesdropping, but those techniques are particularly dangerous. They're hidden. It's a technique that is hidden as opposed to coming in and searching your home. It's a technique that records information continuously as opposed to a one-time shot in your home. It's particularly intrusive because people do private stuff. They say private things on the phone, and it's indiscriminate in the sense that if you're on the phone, a lot of what you say, even if you're a bad guy, is not going to be bad stuff. You know, you could be a bad guy talking to your mom or your lover or ordering pizza. And so what the court said is we need particularly high levels of protection for eavesdropping and bugging, and they came up with these requirements that I just very briefly allude to in that little paragraph, like you can only use wiretapping as a last resort if other techniques like following someone or getting a person to tattle, if those things don't work, you have to minimize non-incriminating information and the like. Okay, so those for us privacy guys, those cases in the 60s, those are our favorite cases. And I would like to pretend like the 70s cases never happened. And unfortunately, it's true.
The 70s were bad on a lot of fronts, not just fashion and music. But so do you mind if I take that? And,
okay.
Well, so just to sum
and
up.
then give it back to me.
Yeah, of course.
Okay.
To sum up a bit, I mean, the Olmsted-Katz transition sounds a warning and a rather depressing one for litigators like me, because it's an example of how the Supreme Court admittedly got it wrong for 4 decades before it realized that people rely on their telephones for private communication, and that for us to be able to have a free society and be able to communicate freely, that needs to be protected by the Fourth Amendment. It took them 40 years to realize that saying, well, you didn't actually intrude on Olmsted's bootlegging shack, so there's no Fourth Amendment interest.
Physically.
It took them 40 years to get from there to, wait, no, actually, the Fourth Amendment doesn't protect places. It protects people. It protects their expectation of privacy. And so Katz remains the keystone for Fourth Amendment protection. This reasonable expectation of privacy test is still the primary test by which Fourth Amendment decisions are made. But coming out of these decisions in 1967, Congress, following the Supreme Court's lead, passed one of the primary laws in this area. Its full name is actually Title III of the Omnibus Crime Control and Prevention Act, I think, of
Organized crime.
of 1968. It's a ridiculously long name. No one ever calls it that anymore. We either just call it Title III or the Wiretap Act. And what this statute did was codify the requirements in the Berger case, what are sometimes called informally the super warrant requirements for a wiretap, which is it has to be a particularly severe crime, it has to be strictly time limited, they have to have exhausted all other means of investigation, they have to minimize non-pertinent information, and a number of other strict procedural requirements. And so this is a wonderful law, it's still in force.
They have to be notified, the person who's targeted or wiretapped has to be notified, and you have to have a remedy if you were wiretapped in error. These are very important things, as you'll see going forward.
And so, still a law that's in force, one that will be amended by ECPA in ways that we'll describe.
All right, so I'll quickly go into the
communications content. So, and the Wiretap Act covers not only wiretapping of your phone calls, but also electronic eavesdropping by placing a bug in a private space. So if they, like you see on The Sopranos where they break into Tony's basement and place a bug, they're affecting a Title III there, if they're following the law. But, so moving on to the 70s, which was bad for both privacy and for the bell-bottom thing.
All right, so the 60s were great because we had Katzenberger, and then we had this Wiretap Act, which I have said is a model for surveillance statutes because it has all these protections in it that ensure that the separation of powers and the use of the judiciary to check the executive protects our privacy. Okay, in the 70s, the Supreme Court considered two cases that still get cited all the time today by the government, and government lawyers say that these two cases govern today, and one of the biggest things that Kevin and I do when we file briefs is to say those cases don't apply, which we'll talk more about. The Miller case involved another bootlegger who the government wanted to prosecute him, and so they asked the bank to give them copies of his bank records, which was deposit slips and checks and deposit statements that they had. And he said, no, I have a Fourth Amendment interest in this information, and the Supreme Court said, no, you don't. There's no reasonable expectation of privacy in these records. And I think I have down here, there's a broad reading and a narrow reading of what the court said in Miller. And so the government says, here's what the court said in Miller. What the court said is, anytime a third party, in this case the bank, holds records of yours, you have no Fourth Amendment privacy interest in it. Okay, now obviously in the internet that's going to be huge because any information you have in the cloud is held by a third party. So if the government's right, we have no privacy online, which some have said. The narrow reading that I'm putting forward, and Kevin, and that has gotten, as you'll see, some acceptance in the courts in the last 3 months or so, is that it's actually more narrow than that, and Miller had to do with a number of things. Number one, these were corporate records of the bank. Number two, he voluntarily and knowingly shared them with the bank because what they were the records were, copies of his negotiable instruments. He said, dear bank, give $500 to this, Still guy, or whatever it was. And so those things together, and the bank was actually considered a party to his transactions under the law at that time. So if you consider all the parts of the decision, then you'd say, well, only those things that could be characterized that way lack a reasonable expectation of privacy. Then, and just to say, there's support for both readings of the case in the decision. Then Smith versus Maryland in 1979, the Supreme Court considered an investigatory technique called putting a pen register on a phone, and pen register recorded the numbers that the phone dialed. That's it. Not whether the call went through, not how long the call was, not who was calling whom, because it was just the phone calling another phone number. And the Supreme Court said, is there a reasonable expectation of privacy in those telephone numbers dialed? And the Supreme Court said no. Now, again, the government has argued that that case establishes, because as the Supreme Court was going through their reasoning, they said, it's not like they were listening to the content of the call, which we know from Katz is protected. So since they weren't listening to the content of the call, and they were listening to only the telephone numbers dialed, there's no reasonable expectation of privacy in telephone numbers dialed. So the government says, anything that's non-content is not protected by the Fourth Amendment. Again, huge implications for today, because that would mean that anything that's not the content of your email and whatever else we figure out as content has no Fourth Amendment protection. I argue, along with other people, including Kevin and others, that there's a much narrower reading of the decision, which is anything which is as non-intrusive and non-informative as the telephone numbers dialed lacks Fourth Amendment protection, but anything in the middle wasn't covered. And again, in the time of Smith versus Maryland in 1979, you had to dial on your rotary phone the telephone number, and you knew that the phone company was recording that information. And the Supreme Court went through that analysis, and you saw telephone numbers on your bill. So a lot of what we're doing today is distinguishing these two cases, and that's what a lot of the fight is, and that's why we have them there. So the next two cases on the handout are the ones that we're going to talk about specifically in our discussion of these two case studies. And just to say, Kevin and I gave this talk in August, a talk similarly, and I had on this handout, we don't know how the Fourth Amendment applies to modern communications. And I had to today fix it, because just since then, September for the case of in-ray application, and in December for Warshak, we now have two decisions that have told us something about the Fourth Amendment online. So to those we turn.
And they actually went well.
Oh, but first I think you wanted to talk about ECPA.
Sure. So spinning off of Smith and Miller, what comes out of these cases is what is called a doctrine, the doctrine of the assumption of risk. That where you have knowingly and voluntarily exposed something to a third party, you've assumed the risk that they're going to share that with someone else. I have a private conversation with Ryan. I assume the risk. He's going to share it with someone else. And they extended this logic to your dialed numbers, to your bank records, even though in some ways this was in tension with Katz, as one of the dissents in Smith pointed out, which is, well, wait, so I make these phone calls over the phone's network. I don't have any control over its passage over the network. I know that the phone company can, and to combat fraud and provides service adjustments, does sometimes listen in. So haven't I assumed the risk there? But apparently not, because Katz was not overruled by Smith. But anyway, so those are the main Supreme Court precedents in the area, which bring us to 1986 and the ECPA, the Electronic Communications Privacy Act, which did basically three big things. It updated Title III to protect not only your wire communications or phone communications, or your oral communications, like communications we're having now, if we were in a place we had an expectation of privacy, but also your electronic communications. Even back in 1986, Congress was well aware of email and wanted to provide protection against its interception. It also, spinning off of Smith, passed, as part of ECPA, a statute to regulate the use of pen registers and trap and trace devices. Pen registers, as Susan noted, are devices that capture the numbers you're dialing. Trap and trace devices capture the numbers that are dialing you. And although the Supreme Court had found no Fourth Amendment protection in that information, Congress wanted to provide some procedure and some protection for its privacy. Although it is incredibly weak, the government goes to the court and certifies that the information basically promises, gives its opinion, that the information it seeks is relevant, and the court, in the words of the statute, shall, i.e. must and will, issue the order authorizing the pen register and trap and trace, and unlike with Title III interceptions, you are never notified when this surveillance is done to you.
And you have no remedy. You have no remedy.
There's no suppression remedy in the statute, and because the Fourth Amendment applies, there's no suppression remedy under the Constitution as well. And also, unlike Title III and like the next statute, I'm going to tell you, there's no civil cause of action whereby you can sue someone who does this to you.
So if the government violates this pen register statute, which would be really hard to do, the only possible recourse would be for the government lawyer who violated it to face criminal charges. And that's never happened. That's never happened. Okay, keep going.
Finally, the Stored Communications Act, the joy and bane of much of my existence. This was a statute meant to address the privacy of communications contents and communications-related non-content records held by electronic communication service providers, which are people that provide you communication service, and remote computing service providers, something we still don't really know what it means. In those days, it meant companies like EDS, where you sent off your payroll to be processed by their big computers and then sent back to you, because you couldn't afford your own computers with a lot of CPU.
Just because I have it on the handout.
Yeah. And so actually, if you guys want to look some of this stuff up, Title III, if you want to give the code sections, is 18 U.S.C. 2511 and following. Pen trap statute is 18 U.S.C. 3123 and following. SCA is 18 U.S.C. 2701 and following. So the SCA is a holy mess. I already explained to you how it's a holy mess when it comes to email. It's not much more understandable in regards to any other communications. But basically, very basically, it provides strong-ish protections for content, as I described, and provides weaker protections for non-content records that reflect who you email, et cetera, such that non-content records can be obtained either with a subpoena directly from a prosecutor or with something we call a D order for 2703D, which is easier to get than a warrant order, while contents are dealt with as I described before. So,
and by the way, for those of you who have the handout, and I apologize for not bringing enough, I have summarized sort of the key provisions of ECPA here in the handout. Okay.
So, in the next 20 minutes or so, we're going to spend 10 minutes talking about this case, Warshock, 10 minutes talking about location, and this case in the Third Circuit that Susan and I both worked on.
Hold on, but before we do, just want to say just a few things before we go on. And that is that, you know, I said before that this is kind of the model. And what's important to recognize is that in each of these areas of ECPA, the law falls far short of this model. And Kevin talked about how we both talked about how the pen register provisions fall far short. The standard is a rubber stamp of relevance. There's no remedy. Here, it's closer to the provisions of the Wiretap Act because when they made this law, Congress just put electronic communications in, but they didn't provide a suppression remedy under the statute. And a couple other little things. And here, and one of the differences is it's just incredibly complicated, but there's a lot of information that can be gathered without a warrant, without notice, and all of it without a suppression remedy. Okay.
All right, so Stephen Warshock, the mastermind, if you will, behind Ensight Natural Male Enhancement. You may have seen commercials for this
Smiling Bob.
This herbal Viagra product late at night on cable television. Stephen was indicted for a variety of strains of fraud in 2005, 2006. That indictment was in part based on email obtained from multiple email providers of Stephen's, whereby the government, using not warrants but subpoenas and 2703D orders, obtained tens of thousands of Stephen's emails. They did this under the Stored Communications Act. And although the Stored Communications Act requires notice when using a non-warrant to get your content, first off, you can go to court and easily get this notice delayed, which the government did. But also, the government then failed to notify him when that order expired, and notified him like over a year later for no apparent reason. We don't know how common this is. I myself have never actually seen a notification of a seizure of email without a warrant, and I question how often the government actually makes that statutorily required notice. Regardless, Stephen, Mr. Warshock, prosecuted for fraud, brought a civil case against the government for this seizure of his email. He could not sue the government for violating ECPA because the Patriot Act actually made it much, much harder to sue the government under ECPA than before. And he instead pursued a Fourth Amendment claim, saying this seizure of my email, my communications content, my private communications content, violated my expectation of privacy, violated the Fourth Amendment, so I am seeking an injunction to ensure that they don't do this again. Susan and I both put in amicus briefs in support of Mr. Warshock in his civil suit, and actually in 2008, we got a wonderful opinion from the Sixth Circuit saying, Mr. Warshock and EFF and Susan are right, that the Fourth Amendment does protect this email, even though it is accessible by the email provider, because it is analogous to our mail, it's analogous to our phone calls, it's analogous to other private spaces where we let people in, but that doesn't give up our privacy. For example, you have an expectation of your privacy in your hotel room, even though you let the cleaning service come in to clean your stuff. You have an expectation of privacy in your apartment, even though your lease gives your landlord clear rights to come in and view waste and ensure that you're not trashing the place. And so we made all these analogies to the court. We pressed these analogies to the court, and the court agreed with them.
And they also made what I would call a normative judgment, that just like in Katz, where they said that the users of the phone are entitled to rely on the privacy of the phone, users of email are entitled to rely on the privacy of email.
Indeed. That victory was short-lived, however, because the en banc court overturned it, saying, well, actually, this isn't ripe anymore, because the government has already gotten your email. It's already indicted you. There's no indication they're going to do it again. So the issue's not ripe, and we're vacating this decision. Very unfortunate.
There's not a real controversy, they said.
Yeah, not justiciable. However, we got a second bite at the apple when, after his indictment and trial, Mr. Warshak was convicted on those many varieties of fraud, and he appealed. And one of the bases of his appeal was that the email evidence should have been suppressed under the Fourth Amendment's exclusionary rule. And so we got a second chance to brief the Sixth Circuit on this issue. And just last month, the Sixth Circuit issued its opinion and once again agreed with us and found that the Fourth Amendment protected this email, citing to the same analogies as before, and specifically and quite effectively dealing with the government's argument about terms of service. The government said, hey, these email providers, and pretty much every email provider, has a terms of service that tells you, well, we may access your email, whether to provide spam filtering or virus filtering, or in Gmail's case, to serve you ads, or otherwise to provide or protect the service. And the court said that doesn't matter. Much like the phone company's ability and sometimes actuality of wiretapping you didn't matter. In part because of the invasiveness of this surveillance, the fact that it intruded into the content of your private conversations.
Yeah, and just to say, the court, this is a really important development because, first of all, because it's a decision recognizing a reasonable expectation of privacy in email. It is the first. And secondly, because the court recognized that email privacy is not all or nothing. And so the government has, for a long time, said, if anybody can get into email, then the government can get in without a warrant. And again, using some analogies that Kevin provided in his briefing and that I, along with my co-author in an article, provided at Patricia Belia, the court said, no, it's more complicated than just all or nothing. But the court did say at a certain point, the service provider has such access to your email that you have lost your expectation of privacy and didn't get into when. So that is still sort of an important open area that when exactly in the earlier decision, the Sixth Circuit had said, the only time you're giving access to your service provider means that you waive your privacy right vis-a-vis the government is when your service provider has total access, sort of audits and reads your emails, has a policy of doing that, and tells you they're going to do it. And so it's not clear, this decision sort of brought some of that earlier decision in, but it's not clear exactly how much, because that decision sort of went away, it was vacated.
So now the question is, how important is this decision? We like to think it's very important, but first off, there's the question of whether it's going to go en banc or not. En banc petitions are due at the end of the month, and we expect the government and the defendant to both file for en banc review. So it looks like we will probably be briefing these issues once again and very soon. There's also the issue of course, this is only one circuit. We don't even have a split at this point, so I don't know that any Supreme Court guidance on this issue is forthcoming. In the meantime, the government will proceed everywhere but the Sixth Circuit, as it always has, which is under the SCA, which on their reading does not require a warrant for practically any email. This is particularly a problem considering the secrecy that surrounds the government's use of this statute. In many cases, the government need not notify anyone at all. There's very little reporting. To the extent the government delays notice, as we saw in Warshak, sometimes they still don't give the notice even after the delay. And so we often, certainly we as civil liberties advocates, typically do not know when these requests are being made, and therefore don't have an opportunity to fight them. Then when we do have the opportunity to fight them, the government withdraws the request so that it doesn't have to risk a court ruling. This is exactly what happened this summer. When Yahoo was facing a D order for someone's email content, the government had applied for the D order in front of a court in Colorado, and the court issued the D order, and Yahoo contested it. And, in a very good turn, got the order and its brief unsealed so that privacy advocates like us could get involved. And so we wrote an amicus brief. We got civil liberties groups to sign on. We got Google to sign on saying, this is unconstitutional. Also, this whole open to unopened thing is stupid, and you should withdraw this order and require a warrant. We did that. The government came back with, oh, you know what? On second thought, we don't actually need this email, thank you. And avoided a court ruling. This has happened to us 2 other times when a court in New York came to us asking for a briefing on a government application, and as soon as we filed our, something saying our intent to file an amicus brief, the government said, oh wait, actually we don't need this anymore. And so we're in a situation where through secrecy and through selectively choosing its fights, the government is avoiding rulings on these critical issues. So that points to a need for simply fixing the statute rather than hoping that the Fourth Amendment can save us. Because if we rely on the Fourth Amendment to save us, it may be 40 years from now before the rule is really established. So,
but Congress, we think will amend the statute.
Yeah. Well, so I'll give a little summary of what's happening in Congress at the very end.
We hope.
But before that, let's talk about location tracking really quickly. So your phone is a tracking device. Your phone reveals your location in a myriad ways, most directly through the cell tower that you're communicating through, both when you are making a call and when you're not making a call. When your phone is simply turned on, it is registering with the closest towers, which can be very close by if you're in a dense urban area or very far away if you're in a rural area. And the company registers this information, both the towers that you're closest to and the sector of the tower. They're tripartite sectors, divided into sectors. And with this data, if we're talking about real-time tracking, the phone company, at the request of the government, can triangulate your position to a fairly high degree of accuracy. If you have a GPS chip, they can derive it to an incredible accuracy. And this raises obvious privacy concerns. We had always assumed that the government used warrants when it wanted to do this kind of prospective or real-time tracking. There's a reason for this. Under these statutes, well, this kind of data isn't content, so they're not using Title III for it.
Wait, we don't know if it's content.
Well, I mean, the cell site location information is not content of a communication. There may be contexts where location is content, and I'll get to that. But so they're not using Title IIIs for it, we assume. And Pen Register, they actually can't use this for location tracking because a law called CALEA passed in the 90s. Congress recognized this was so low and location was so sensitive, they didn't want the government to be able to use this. So they said, you can't rely solely on a Pen Register order to do location tracking. And we figured, well, they're not using the Stored Communications Act to do this because this is about stored stuff. This isn't about real-time monitoring. That's what these statutes are about. So we always assumed they were using search warrants for this kind of tracking.
For prospective location data.
Prospective location tracking. We were wrong. We found this out in summer of 2005 when a magistrate took the rare step of publishing his denial of a government request to track a cell phone in real time. Judge Orenstein in New York. He did everyone a great service. Apparently the government had been doing this. Its standard procedure was to do this without a warrant for over a decade prior to 2005, and we had no freaking clue, which brings me back to the overall concern about secrecy point. We often don't know how the government is using these powers. And it turns out what the government had been doing was actually misusing the Stored Communications Act and getting D orders to do this kind of real-time tracking. Once it became public what they were doing, they changed their position. And they actually said, no, wait, what we meant was we were asking the court to combine a D order with a Pen Register order. And basically take this order that can't do real-time tracking and this order that can't do real-time tracking and combine it to do real-time tracking. Basically arguing that 0 + 0 = 1.
And Judge Smith is the other magistrate judge who issued some really remarkable decisions on this. And he also has, he's out of Southern District of Texas, and he also has an article about all the secrecy that Kevin's been talking about, and how a lot of these orders are gag orders that are issued along with them. You know, they're issued under seal. And his article is called Kudzu in the Courtroom, and I highly recommend it, along with an article Kevin wrote in the USF Law Review about all the secrecy. It's called Only the DOJ Knows.
Smith's article is great, and the reason Kudzu is all of the sealed applications, he says, over the decades are piling up in the clerk's office and taking it over like kudzu, which is a aggressively growing vine type plant.
Oh, I didn't know that.
But anyway, and so since then, EFF has been involved briefing a lot of courts that have come to us saying, I've got one of these hybrid applications, what should I do with it? And there have been about 36 decisions. About 2/3 of them have rejected the hybrid idea, about 1/3 have accepted it. In the meantime, what we hear anecdotally is that most courts are still just signing whatever the government puts in front of them, which again points toward, we're not going to get a clear answer on this until Congress updates the statute. But so then that takes us to a related location issue, which is, what does the government have to do if it wants to obtain your stored cell site information about where you were, rather than where you are? And that question brings us back to the Constitution, because the fact is, under the statute, we think it's clear the government can get those records without a warrant under the statute. So we have been pressed into arguing, and have argued strenuously and somewhat effectively, that the Fourth Amendment protects this data despite those awful 70s decisions. And Susan will tell you a bit about that.
Yeah, so now we're talking about access to historical location data by the government. And in practice, what they're doing is going in and giving these D orders. And in the handout, the D order, you have to say that the information is relevant to a law enforcement investigation. So in practice, that means that the government's asking for this information for lots of people. If they have one person of interest, they'll ask for the information for everyone the person called. It could be, people who are not suspected of crimes at all, but just know people who are suspected of crimes. So this is why, I'm concerned about it, because it allows fishing expeditions and intrusions on the privacy of people upon whom sufficient suspicion has not fallen. And so they go in, and it's always ex parte by just the government, and they say, we satisfied this order, this standard, and now we want all the location records that the provider has. And so a lot of magistrate judges have said fine, but in a couple of years ago, a magistrate judge in Pittsburgh said, you know what, no. I think you need to get a warrant, and ended up appealing. The government appealed that to the district court and appealed it to the Third Circuit, and Kevin and the EFF and ACLU and CDT wrote a brief, and I wrote a brief, and the courts referred to some of my scholarship. And we convinced the Third Circuit of two things. One, the Third Circuit came out with a decision in September, and they said, number one, the third-party rule does not apply to this data. So that was a big win. They said, and they accepted our arguments that location data is not the same as telephone numbers dialed or bank records, because we don't think that you give it away voluntarily, knowingly, the same way you do these other type of information. They could have said more, but that's basically what they said. So, because the government had gone in and said, why are you even thinking about whether the Fourth Amendment applies here when so clearly Smith and Miller make the issue go away and apply? And the government said, no, not so fast. So the government rejected the third-party rule, and then had to get to the question of whether or not the gathering up of location data implicates your reasonable expectation of privacy. And that, they said, was a more complicated question, and they looked at another set of cases we haven't discussed, having to do with the use of bumper beepers or caro and knots, where they tracked a car through public spaces. And the whole question is, when they get this location data, is it sufficiently intrusive and precise, what the court asked, to figure out if you're in your home? And we're trying to get them to see that, well, I'm trying to get them to see any of them, that it can, even if it doesn't, first of all, you can infer that someone's in their home from their location data. And second of all, you can intrude on privacy even without exactly knowing someone's in their home, because this location data provides a virtual map of someone's behavior and activities over a period of time, and tells us who they've met with, where they've gone, what their patterns are. But the Third Circuit remanded to the magistrate judge to figure out if the information intruded on an expectation of privacy, although what EFF and the other civil liberties groups had succeeded in doing was saying that they can construe the statute to permit a judge to require a warrant without finding the statute unconstitutional. So we've kind of divided up now, the civil liberties groups and me, where these guys come in and say, we just have to have a question of constitutionality to permit the magistrate judge to require a warrant. And I come in and say, look, this thing's just unconstitutional. And I take a more extreme position based on my scholarship. So that's where we are. I think unless Kevin has something else to say, we should take questions.
We should take questions. Well, actually, no. I should let you know what's happening in Congress. For the past couple of years, I've been working very closely with a colleague, Jim Dempsey at the Center for Democracy and Technology, to bring together scholars and other stakeholders in this area to come up with principles for ECPA reform. And we came up with some principles, which I'll briefly outline, and have recruited a very broad coalition of not only civil liberties and privacy advocates, but the companies themselves. Google and eBay and Microsoft and Facebook and AT&T. You know, I'm suing AT&T in another case, but at least on this question, whether or not this law is out of date or not, we can agree on that. And so this coalition, called the Digital Due Process Coalition, you can find information about it at digitaldueprocess.org, has publicized a few principles for ECPA reform. We've been working very hard on actual draft statutory language to share with congressional staff and have gotten Congress interested. There were 4 hearings last year in front of the Senate and House Judiciary Committees about ECPA reform, and we do expect there will be ECPA reform bills early this session of Congress. So very quickly, the 4 things that the coalition is pressing for, not an exclusive list of all the things that need to be fixed in ECPA by any stretch, but a good starting point for the conversation are, first, content. Content of your communications stored with a third-party online service provider should be protected regardless of how old it is. We're protected by a warrant requirement. Regardless of how old it is, regardless of whether it's stored by an electronic communication service provider or a remote computing service provider, regardless of whether it's opened or unopened, regardless of whether it's in your inbox or sent folder or drafts folder, whether it's Facebook or your email provider or Twitter or whomever else. Second, location. Location information should be protected by a clear warrant requirement, whether we're talking about retrospective records or prospective tracking. And so we can put an end to all of this tiresome litigation about whether these hybrid orders are a bunch of BS or not. Pardon my partial French. Third, heightening the standard for pen registers, particularly after the Patriot Act extended the pen register statute to electronic communications data. We have a problem. Not only do we have a problem of trying to distinguish what's content and what's not. For example, we in the DOJ seem to disagree about whether or not clickstream data about what sites you're visiting is content or not. We also have a problem of, we now have this rich stream of data about who you are communicating with and how and for how long and how many bytes you're sending, what IP addresses you're sending from or visiting, all available with this secret and incredibly easy to get order. And so the modest proposal of the coalition is to heighten the standard of the pen register statute to at least the somewhat more reasonable standard of a D word. And then finally, our 4th principle deals with something we've seen before, which is mass requests for data. Data that's not particularized to a certain subscriber or account. We've seen this, for example, when the government gets information on every cell phone that contacted a particular cell tower near a crime. We've seen this in subpoenas to eBay for details on everyone who sold anything in a particular jurisdiction. Perhaps most troublesomely, in a case that EFF was involved in, we saw a subpoena to a political news site asking for the IP address of every single person that visited any page on that site on a particular day. We've seen these very broad fishing expedition requests. And the modest proposal of the coalition is that to the extent the government is not seeking the information of a particular user or particular account, it must get a court order. It cannot rely solely on a subpoena written off by a prosecutor. In addition to those 4 principles, EFF would support other reforms to ECPA.
Suppression remedy.
A remedy to have suppressed any information that's obtained about you in violation of this statute. Right now, the only suppression remedy in the statute is for illegally wiretapped phone calls and illegal eavesdropping of your private conversations. And more reporting about how the government uses these authorities, and more reasonable limits on secrecy regarding particular orders. So we've been working very hard on this. We're very hopeful that Congress will move quickly this year to address some of the more obvious problems in ECPA. And now let's take questions. Yes, sir.
There was this, you said something about when location is content, and I'm wondering if that's kind of what you were talking about, like building up these aggregated maps, if you're then counting that location as content instead of the route.
Yeah, and actually, no, I think what we're,
I mean, I know what I was
yeah,
talking about when I said, so, and this is a position we've convinced several companies to take, which is good because it's the correct one. I think that communications, location information is content when it's actually what you are saying to someone else as opposed to information that's generated by the fact that you're talking to somebody. The best examples of this would be friend finding services like Looped or Google's Latitude, where the content of your communication is, hi friend, I'm over here. And we've blogged about this, we've worked with Google and Looped, and their compliance position is that is communications content under ECPA that requires content process. Similarly, the geotag on your tweet, that is not non-content information. It is actually the content of your communication with the people you're tweeting with.
But in that particular example, then it's kind of more publicized. It might not be the reasonable expectation of privacy for tweet.
If it's a private tweet, one thing. If it's public, I don't think you have an expectation of privacy. But also, the government doesn't need to go through any of this process to get it. It just goes to the web page, and so we avoid those fights.
the only thing I would add is, what I'd like to say is the content, non-content distinction is not a constitutional distinction. It's a statutory distinction. So so that's why, is location data content? I mean, I think it's as intrusive as content. Its acquisition is as intrusive. So that's the only reason I sort of do that a little bit. Okay, you had a question.
The reasonable expectation of privacy seems sort of peculiar as a legal standard insofar as it's so subjective and sounds so subject to public opinion. Is it, in theory and in fact, is it evolving because judges think that in the new world everybody is showing naked pictures of themselves on the internet and yelling on the phone in public instead of speaking quietly in private places? Or does it just mean, along the lines of gentlemen don't read each other's mail, that it's whatever the Supreme Court thinks is or is not allowable?
Yeah, let me take that. It's a good question. And
also I'm sorry.
Well, I'm not going to remember too much, so.
When Silicon Valley CEOs get up and say everything you know about privacy is wrong, are they trying to affect that environment, and are they affecting it?
Well, I think they're trying to reduce their liability or responsibility, but there's been a lot of scholarship written about reasonable expectation of privacy and criticisms of it, including by me. And the reality is the Supreme Court has to come up with, there has to be some test. And if you look at all the alternatives, it's actually not a bad one. But it does require what I call a normative understanding or normative judgment about how we want to live. And it can't be just a positive discussion of sort of what people expect. It can't just reflect what people expect, because then you're right, as soon as people could just give up their privacy, even if they shouldn't, or the government could just, announce, you no longer have privacy in X, we're going to search X, we're planning to wiretap your calls without a warrant, and now do you have an expectation of privacy in it? So so there has to be a normative component. In practice, when the courts look at reasonable expectation of privacy, they don't tend to look at surveys or try to figure out what people really expect. It's more they just look at precedents. And what I've said in my scholarship is they tend to take shortcuts because it is too hard to figure it out. So they'll just say, oh, hey, wait a second, third party wrote, boom, done. Or, oh, hey, non-content, boom, done. And what I think they need to do is actually think about the technology and think about how we want to live, just like they did in Katz. And what I see is, what gives me optimism is that courts, for example, in Warshak, and to a lesser extent in the Third Circuit case, have been doing that. So.
I wanted to quickly address that as well, because I think it's actually sort of the reverse. You suggested, are courts being swayed by the end of privacy talk, or the fact that people are more comfortable sharing more than they did before and have the capability to share more than they did before? And I tend to take a sort of legal realist view that it's the reverse. That is, as our aging courts, as younger judges are on the bench, judges who are actually familiar with and rely on these communications technologies themselves for private communications, they are much more likely to make the right normative judgment, in our view, because they go, well, gee, I use that Gmail thing, and I have years of really private stuff there. While an older judge whose only interaction with email is his secretary or his clerk printing it out for him is going to have probably a different perspective. This also highlights, for you law students, the critical importance of the clerks.
Yeah, the clerks.
Who know these technologies to make sure that their judges are well educated about them and understand the implications when these issues come up.
Right, Ryan.
Oh, sure. I just briefly. So, are you at all concerned that there are a set of technologies that exist or right around the corner that don't seem to fall into any of the definitions of ECPA? I know one of the debates is exactly what constitutes the kind of service that's covered. So, a nanny cam, a security webcam, those kinds of things. Are there examples you're worried about there, or are you just really worried about the bulk of consumer-facing technology?
I mean, we're certainly worried about that, and that's one of the reasons why in our drafting for DDP, we've actually eliminated the distinction or the importance of the definitions of electronic communication service and remote computing service. But I think social networks in particular are posing the hardest questions right now in terms of whether or not those communications are in electronic storage or not, whether or not they are providing a communication service or a storage service. That's actually something I'm going to be trying to attack or address in the article I'm working on. It's a hard issue. Luckily, Facebook, I'm not always a fan when it comes to their privacy practices, but when it comes to ECPA compliance, Facebook has taken a very strong stance that everything that you upload to Facebook is content that is in electronic storage and therefore receives the strongest possible protection under ECPA. Does every other service provider take that position? Probably not. Would every court agree with that interpretation? Probably not, though I certainly hope so, and I hope my article will help them reach that result. But it is a very difficult question, and it's a question that you have, a problem that you're going to have with any statute that tries to specifically address technology, because it changes so fast.
And what I say is we've had this problem for a long time. I mean, I think that the ECPA hasn't covered web information, for a long time. I mean, it's written in 1986, so I don't think it's a new problem. I mean, I think the Department of Justice will argue that the statute covers what they want it to cover because it gives weak protection. But I've always tried to make space for the argument that the statute doesn't cover it, and let's talk about what the Fourth Amendment says. And I think that will continue. But I think Kevin's right. The challenge is how to, when you do come up with a new statute, how do you make it fit make it relevant as long as possible? But what's the story with going ahead? Can we stay another 5 minutes, or does the room need to be used?
I don't think the room is going to be used. People can ask them questions.
Okay.
We don't want to keep everyone here indefinitely.
Okay, because we're.
I mean, we're done. You're free to leave, but if anyone has additional questions.
Yeah, we're happy to stay a little while. Huh? Yeah.
This man has been.
As I understand it, you don't need a warrant to follow me down the street or follow my car. So one could argue that the GPS-based mechanisms are a remote viewing version of the same thing.
Yeah, no.
Why should that then require more permission than following me down the street?
You want to take it?
Sure. So the Supreme Court agrees with your logic, or at least agreed with it in terms of beepers that were attached to big drums of drug precursor chemicals that they wanted to track around. And that's what these cases in the 80s, Caro and Knotts, were about. And they held that to the extent the beepers only revealed stuff that could be viewed from public, like by, say, a cop that was following you, that was not protected by the Fourth Amendment. You had no expectation of privacy because you exposed those movements to the public. However, in Caro, the court also held that to the extent the beeper was carried into a private space and the government tracked it while it was in that private space, Something that happens a lot more often with your cell phone than with a 50-gallon drum of chemicals, or 5-gallon drum of chemicals. That does invade your expectation of privacy, and if it was obtained, and if they did that without a warrant, it would be suppressed under the Fourth Amendment. So our argument is, well, cell phones go in and out of private spaces all the time, and to the extent they can monitor your cell phone and establish that your cell phone is in a private space, under CARO, under 25-year-old precedent, that is a search requiring a warrant. Importantly, there's also been a new development. Not only was there this great Warshak opinion, not only this great Third Circuit opinion, but the other big privacy court news this year was a decision by the DC Circuit in US v. Maynard, which involved a GPS tracking device attached to a car, which they used for a period of over 30 days. And in that decision, the DC Circuit, and en banc was denied here, but like with Warshak, we're waiting to see if they're gonna,
No.
I'm sorry, en banc was denied. We're waiting to see if they're gonna petition for cert. The DC Circuit held, and there was no evidence that the car or tracking device had gone into a private space. Despite that, the DC Circuit now, and again, the en banc court let this stand, held that this kind of pervasive, ongoing tracking, as distinguished from, say, a radio-based bumper beeper like in the 80s cases that helped facilitate visual surveillance. This replacement for visual surveillance that allowed them to comprehensively track everywhere you went over a 30-day period was distinguishable from the cases in the 80s. And that, yes, you may have, exposed discrete movements to the public, but we reasonably expect that there is no entity that can actually pull all of those together, so that we have not really exposed to the public our movements over time. And that such surveillance that paints an intimate portrait of our movements, even though exposed to the public, violates the Fourth Amendment. Or rather, you have an expectation of privacy in that information such that warrantless monitoring of that type violates the Fourth Amendment.
It'd be
Who is it that is, that issued that?
DC
DC
Circuit.
Circuit. Not your most liberal of circuits. So.
Yeah.
I'm just wondering about this distinction of what is and is not content. I mean, it seems a bit absurd, and I can imagine a more radical argument that, for example, the fact that I haven't spoken to my wife on the phone for 2 weeks is itself content, right? That the absence of communication is something that should be protected
I like that.
as well. So I'm just wondering, like, with telephones, the example that I gave is telephones, but with email as well. Do I write you with my Stanford account or my Gmail account? All of these things that really do carry content in some sense.
What question are you? I don't understand what question you're asking.
I think he's agreeing with you.
No, but I don't understand. What question are you asking?
Well, I'm trying to understand where one draws the line of what constitutes content.
Where Congress draws it, or where the courts draw it?
Well, where the courts draw it, and like what serious arguments the court has entertained that perhaps content should be more broadly construed.
They haven't entertained any arguments.
I mean, in the constitutional discussions, the court's been given pretty straightforward examples. There's the message content in your email, which is clearly content. There's what you say on the phone, that's clearly content. There haven't been a lot of cases arguing that transactional or addressing data is content or should be protected as content, although there's one decision in the Ninth Circuit, US v. Forrester, where despite excellent briefing from the ACLU and the FF, the court found that IP addresses and email addresses were not protected as content, and that you had no reasonable expectation of privacy in them. But I think your overall point, and for what it's worth, the statute defines content as any information.
Yeah, it's on the sheet.
Any information revealing.
Statute defines it as any information concerning the substance, purport, or meaning of the communication. The strategy I take is not to have the court accept other things as content. It's for the court not to use content, non-content, as a way to reject protection of non-content. So it's to recognize that to the extent content and non-content have become important, that's something Congress has done. And that, again, Smith versus Maryland wasn't about content, non-content. It was about content, telephone numbers dialed, and that there's all this area in the middle. So that's how I think about content. So it's not about getting the court to say, you know, that's really content. It's about getting the court to say, you know, we can protect things whether or not they fit into this thing called content. Fitting, you know, not fitting into our narrow definition of content does not necessarily mean that you're not going to be protected.
And I mean, to build on that a bit, yeah, I mean, Smith v. Maryland did rely on content, non-content distinction to the extent it distinguished Katz by saying, oh, well, that was content. But I think what it was doing there was using this content concept as a proxy for level of invasiveness. And I think the point you're making is that this traffic data, the analysis you can do on that, can be as revealing in some cases as the stuff you consider content. And we agree with you on that.
Absolutely.
And that's one of the big tensions in this area of the law.
But I don't even think they were saying that it was, yeah, I think content was a proxy for intrusiveness, and they were just characterizing what Katz did. Katz protected the content of your communication. That's just how they described it. They weren't, you know, nobody was asking in Katz whether anything else should be protected. Which, should we protect conversations, content, or not? So you had a question up there. Do you still have it?
Yeah, I do. I have two. One about that boss level first. So you talk about an expectation of privacy. It seems like most of your work is with government intrusion. Is that correct?
Yeah.
And
Because
so,
of the Fourth Amendment, because of the statute.
Okay, so employers have posted no expectation of privacy
Yep.
when they do their networks, and I'm wondering, and I know those have been upheld in some areas and not in others, and I'm wondering how that impacts the fact that your employer has a no expectation of privacy approach impacts whether the government can then come in and say, well, therefore you don't have an
That's a great question. And this is one of the things that's open after Warshop. I mean, I think you can make an argument that, you know, again, the employer's access for employee purposes is analogous to the service provider's access for service provider purposes. And that under the Warshop reasoning, allowing the employer in to run its business does not mean you've waived your expectation vis-a-vis the government. And in fact, there's a great case that came out of the military court called the Long case, where they said this guy allowed the network manager to read emails to make sure that he wasn't, you know, child pornography storing and the like. But then when they came in and just looked through for investigative purposes, the court said they needed a warrant because they changed the basis. But I think there's, but we don't have the cases yet.
Yeah, and I mean, it's a little broader than that because that's true, that works if your employer is Wells Fargo and they're looking to make sure you're not stealing money, and that's what they're checking your email for. But if you're at someplace like Stanford where there's we're like a little city, and so you've got lots of different reasons why Stanford could be looking at email from student safety, from faculty.
But you know, but the question is, are you law enforcement or not? Are you an agent of law enforcement? Are you a state actor? Does the Fourth Amendment apply? I mean, there's a case called O'Connor versus Ortega.
Well, we are though. I mean, we have a police force.
Then you should be following O'Connor versus Ortega, right? Which says, you know, the inquiry is different if you're looking for investigative, you know, for workplace reasons versus for
or fiduciary responsibility for students, or I mean, it's not just workplace. You know, we are in lots of different things to lots of different people.
I mean, I think part of the ultimate question is, even under the Warshop opinion, it may be the case that you have given up your expectation of privacy. Not that I like that or necessarily agree with it, but I mean, the language that you cited about, you know, to the extent you give like unchecked access, you've you know, agreed to auditing, you know, of any and all of your emails for whatever purpose, it's going to be harder to make a expectation of privacy argument there.
I mean, the way I look at it is the service provider, whether it's an employer or not, sort of a party. But I'm not sure, I don't know that the courts would go that far.
The other question I had was, and I just don't understand this, so in my mind, a telephone number is envelope information, and I'm curious as to why that, not the content, non-content, but in my mind, knowing where I am addressing my telephone messages to, or who I'm conversing with on the telephone, is equally is the same as knowing what address I'm going to with my cell phone.
Yeah. Well, so, you know, we had 1 hour to, you know, to make like I mean, I can't believe we even tried to do it, but to take you on a whirlwind tour of all of surveillance law, statutory and constitutional. So, you know, Kevin and I each wrote 30-page briefs showing how to distinguish Smith versus Maryland, and it has to do with both the nature of the way what you know about the information, how you disclose it, and how intrusive it is, and how much more that information conveys than telephone numbers dialed. So, I mean, both of our briefs are up online on the EFF site. But, you know, certainly that's the argument that government tried to convince the court of. And they rejected it in the Third Circuit. But not in other courts. Some other courts have accepted it.
The Third Circuit itself has articulated an argument here, and it hinged on the phone number you dial. You are actively, directly, clearly, knowingly transmitting that information to the phone company, while your location is indirectly exposed by the fact you're communicating with certain cell towers, and you don't in any way directly convey that to the phone company.
But my email address, let's use email as the proxy for phone. Email address and IP address, those are all virtually the same.
Okay, so I'm not quite sure what the question is then. Are you asking
Question is, why doesn't
what is the argument that addressing information is always as intrusive as content, which I don't think either of us
I think she's saying,
No, I'm saying.
why doesn't Smith versus Maryland cover those cases?
Yes, and why isn't it being overturned if you're arguing that the email address is not content, that the IP address is not content, that you shouldn't get all the IP addresses? If just addressing information is not content, and I agree, then why doesn't that kind of overturn the concept that recording of my phone number also should not be considered to be accessible?
Okay, the recording of the phone number was decided in 1979, when the only thing that was recorded was telephone numbers dialed, recorded on a paper tape. A lot of stuff was not recorded, and the Supreme Court specifically relied on the lack of information included in that pen register data. Okay, so the question is, are you just gonna say, well, hey, non-content information or envelope information or whatever shortcut you want has covered, you know, we're all done? Or are you gonna say, okay, now we have something new, now it's 2010, and we have to look at the information and how it's gathered and figure out if we should apply the same approach? And the Third Circuit was convinced by us that it couldn't just knee-jerk apply a case that had been decided in 1979 dealing with much different data.
And why doesn't somebody go back and then argue that case is no longer correct either?
Because that's not how you do it, because it's a Supreme Court case. And so you have to wait till you get to the Supreme Court. Until you get to the Supreme Court, you distinguish it.
All right, so one more question, and probably we should give the room up eventually, so we
Who's had their hand up the longest? Let's be honest here. I've seen
Let's
you
just
with
take
your hand
both
up for a
quickly.
while.
Let's take both quickly.
I was going to ask about encrypted communications. This is sort of the legal framework to try and protect it. Do you guys deal much with or see encrypted communications as kind of a self-help way of, I don't really trust the law, I'm only going to store my email in an encrypted format?
We are absolutely pro-encryption. We have in the past supported the development of encryption tools such as Tor, which is an encrypted distributed proxy network. I certainly recommend if you store data in the cloud, considering the weakness of protections, use encryption wherever possible. We're also very closely watching what the government's proposal is going to be regarding CALIA. You may have heard of this Communications Assistance for Law Enforcement Act, which mandates interception capability for certain communications providers. The chief counsel of the FBI has said in the New York Times that she wants to get something passed that would basically break encryption, that would force providers to be able to decrypt your communications for the government, and we will be vociferously opposing that if anything like that is introduced in Congress.
Do you see self-encryption as sort of the way to go, or do you think you can provide a good legal framework that can balance?
I mean, I think it's kind of apples and oranges. I mean,
Yeah,
ideally,
totally.
I would love to see a world where everything is easily encrypted by everyone. We've wanted to see that world for decades now. And the fact is,
Don't hold your breath.
widespread encryption, it hasn't happened yet. And I certainly don't have the magic answer to make it happen. But I wish it were standard. What's the phrase about wishes? Anyway.
The road to hell is paved with good intentions?
Not that one. But anyway, what I wish is beside the point. The reality is that many people don't use encryption. Most people don't use encryption if we're talking about, say, encrypting your email messages to and from. But certainly if you're storing data in like a remote backup or something like that, make sure it's a service where it's encrypted such that only you have the key. Because if they do have the key, they can and will decrypt it when the government comes calling.
And I just want to take this opportunity to say for the record, I don't work for EFF. And so when he says we, he means we at EFF. I'm a law professor, I work for USF, and I write amicus briefs, and we coordinate.
And you don't want people to use encryption?
And no, I didn't say that. I just said when you just were saying a lot of we.
Yeah.
And I'm just saying that's the EFF position. We doesn't have an official encryption position.
I'd also point out that using encryption strengthens arguments for a reasonable expectation of privacy, although certain former DOJ people have written academic articles saying that that actually has no impact on your expectation of privacy, that it's more analogous to you speaking in a different language, and does not speak to whether you have an expectation that that communication will be intercepted or not.
All right, one
Anyway.
last quick question. What did you?
Do you have any intelligence on what went on behind the curtain in Twitter and why that de-order, like a gag order on that de-order was lifted?
I'm actually representing one of the targets of that de-order, and so I'm limited in what I can discuss other than to say that we have filings due on Wednesday, which is why I need to run soon. I mean, I hope and expect that Twitter sought to unseal that order or prevailed upon the government to ask for the unsealing of that order because it realized this was an issue of great public importance and wanted to enable folks like us to get involved.
There's something published about that online, so you might be able to.
Well, thanks again. This was fabulous. Thank you so much.
Thank you.